All rise. First District Court of Appeal is now in session. All who have business before this court draw near to your attention, ye shall be heard. May God save these United States, great state of Florida, this honorable court.
Thank you. You may be seated. Good morning and welcome to the first DCA. We have one case on our docket this morning, case number 23-2252, Secretary of State Byrd and others versus Black Voters Matter Capacity Building Institute, Inc. And others. If appellants are ready.
Thank you, Your Honor, and may it please the Court. Henry Whitaker from the Attorney General's Office for the Secretary of State. I was going to save 4 minutes for rebuttal, subject to the Court's questions, of course.
Thank you. And I think we're allocated 40 minutes aside, and you all are splitting, so you can handle that on your own.
Okay. Understood, Your Honor. Thank you. The plaintiffs here seek to invalidate the state's race-neutral map in North Florida and replace it with one that contains a district guaranteeing that black preferred candidates always win. That is a racial gerrymander, and the law did not require the legislature to draw it for two principal reasons. First, plaintiff's non-diminishment claim is premised on perpetuating and giving effect to a benchmark from the benchmark district from the prior map that was itself a racial gerrymander.
Counsel, the prior map that the plaintiffs claim is a benchmark, was that adopted pursuant to a partisan gerrymander claim or a racial gerrymander claim?
The Florida Supreme Court, Your Honor, in the prior apportionment litigation, adopted that district as a remedy for a partisan gerrymandering claim. And I think that fact is significant because I think it reveals that the issue that the court faces here and what was before the Florida Supreme Court back then was quite different. I mean, the choice the Florida Supreme Court was faced in Apportionment 7 was between a gerrymandered north-south district that the legislature had enacted as a remedy for a partisan gerrymander and the east.
Right, so in that case, the Florida Supreme Court invalidated a black performing district, correct? Representative Brown's district.
Yes, that's.
And to rectify what they saw as a partisan gerrymander to benefit Republicans, they adopted this east-west district, correct?
Yes, Your Honor, that's correct, and I think that is answers the argument, I think, effectively.
So how can this be a benchmark seat if it wasn't adopted to remedy racial discrimination? CD5. That's your argument, the Secretary's argument, right? It can't be a benchmark because it wasn't adopted to remedy racial discrimination.
Well, our argument, Your Honor, on the benchmark is that the benchmark district that the Florida Supreme Court adopted, the east-west configuration, was done, racial considerations predominated in the drawing of that district.
Well, it wasn't even drawn, it was ordered by the Florida Supreme Court.
Yes, that's right, Your Honor.
So it was ordered to remedy partisan gerrymandering, correct?
Yes, that's correct, Your Honor.
In fact, the Florida Supreme Court they stated that it had some black performing characteristics, but it was done to remedy partisan gerrymandering, right?
Yes, that's.
So how can it be a benchmark under Section 5 of the Voting Rights Act? If you don't have a district drawn to remedy racial discrimination, what is there to diminish?
We certainly agree, Your Honor, that.
We argued it, the Secretary did.
Excuse me?
The Secretary argued this, correct? That there is a failure of proof by the plaintiffs because there is no district that was drawn to remedy racial discrimination.
Our argument, yes, Your Honor, is that CD5 in the old map is certainly not a valid benchmark from which to measure diminishment.
And you don't need to reach the Equal Protection Clause argument, correct? If the plaintiffs can't show a district that was drawn to remedy invidious racial discrimination as described in Miller, there's no district to diminish, correct?
I think, Your Honor, I'd look at it a slightly different way, actually. I mean, I think that the mere fact that it was drawn to remedy a partisan gerrymander wouldn't detract from the fact that it potentially could be a valid district. I do think that we have shown that there is a further problem with that district, not simply the fact that it was drawn to remedy a partisan gerrymander, namely that if you look at the reasons why the Florida Supreme Court drew that district, racial considerations predominated, and that stems fundamentally from the application of the non-diminishment principle.
Is it your contention that we can't be conscious of race in considering districts as opposed to having race predominate in the consideration of a district?
No, Your Honor, certainly not. And that was a proposition that was rejected by the Supreme Court in Allen versus Milligan. But what we have here in the application of the non-diminishment principle is much, much more than mere race consciousness. The non-diminishment principle establishes and requires the state to hew to a relatively rigid racial target that is set by a benchmark district. There is a given level of voting strength.
I mean, aren't you basically asking us to say that apportionment 7 and 8 were wrongly decided?
Certainly not, Your Honor. And as I was, I think, discussing with Judge Thomas, the issue in apportionment 7 and 8 was quite different. The Florida Supreme Court in those cases was not faced with this particular issue. They were faced with a choice between which of two districts the legislature's north-south proposed configuration enacted, they actually enacted it into law, and a proposed east-west configuration. And the issue there was whether which of those two districts better complied with the Tier 1 and Tier 2 standards set forth in Article 3, Section 20 of the Florida Constitution. So this issue was not teed up for the Florida Supreme Court then, Your Honor. And look, I think that this case, for example, is quite different from the Section 2 issue that was before the U.S. Supreme Court last term in Allen versus Milligan, because the issue in a Section 2 claim and what the U.S. Supreme Court was discussing was whether, in the context of the Section 2 claim, in particular establishing the prerequisites for a Section 2 claim, whether race necessarily predominates. And the court said no, and one of the things the court stressed was, in analyzing a claim, a vote dilution claim, which is also present in Section 20, that permits the state to respect traditional redistricting principles. A vote dilution claim is trying to prevent, in essence, a state from engaging in racial gerrymandering.
Can I go
Counsel,
back to, go ahead.
if let's just take a step back. How does a trial court determine what a benchmark district is in the context of the Fair Districts Amendment?
Well, Your Honor, you would look to the last legally enforceable plan. That's the standard set forth in the Department of Justice guidelines, which Section 5 guidelines, which the Florida Supreme Court has used to interpret the non-diminishment.
So understanding that, so the United States Department of Justice has identified a number of Florida counties and districts that would have been benchmark districts. So beyond those, did 2010 redistricting set a new line that anytime there is a district where a minority is winning, that it can no longer be diminished? There's a new benchmark every time that happens.
What I think and as the Florida Supreme Court has construed it, what the non-diminishment principle does is it says you have to protect black performing districts. Yes, Your Honor. And in order to determine whether there is a black performing district in the old map and whether the new map diminishes that, you have to look to a benchmark district. That district, however, must be one that is legally enforceable. And our submission here is that CD5 is not a legally enforceable benchmark from which to measure diminishment because, for all the reasons we've been discussing, it was a racial gerrymander. It is a sprawling
But it wasn't challenged, right? So we had 3 elections where Congressman Lawson served. My guess is if you would have, before a vote that he made and D.C. brought some quo warranto action, by what authority it was, well, I got elected in this district. And, you know, in that sense, it was valid. You talked about validity earlier. You had a valid congressman serving in a district. Now, a claim may have been brought, it seems, but no claim was brought, gerrymandering-wise. So why, when you reach 2020 and start drawing lines, aren't you just looking at the fact that you have this district and the constitutional fair districting amendment principles talk in terms of diminishing where racial minorities elected the candidate of their choice, so that happened last time. So why isn't that the benchmark?
Certainly. The mere fact that the district was in effect at one point, Your Honor, establishes that it was enforceable, perhaps, and enforced as a matter of fact. It doesn't support that it was necessarily legally enforced. And I'd point, Your Honor, to the U.S. Supreme Court's decision in Abrams versus Johnson, which treated as an invalid benchmark a district that was in effect for a time. Now, it was subsequently invalidated by the U.S. Supreme Court. But this court, no less than a court that would have been faced with a challenge to that benchmark district while it was in effect, is perfectly, I think, competent to make a determination that the district, when it was in fact a racial
Counsel,
gerrymander.
let's try it this way. The Secretary argues in pages 64 to 69 of the initial brief that, in fact, the Appleby's case failed to prove its case because benchmark CD5, your argument is it's not a benchmark. It was never adopted to remedy racial discrimination, correct?
Yes, it was
It
not.
was not adopted to remedy racial discrimination. It was a substitute for the North-South Snake District that Representative Corinne Brown had that the Supreme Court said benefited Republicans too much. So they ordered this East-West District to remedy partisan gerrymandering, correct? We're going to go through a series of steps, right? Right?
They did say that, Your Honor, and I guess.
So my second question then is, we are obligated as a court to avoid constitutional issues and resolve a case on non-constitutional grounds if we can do so, right?
Certainly,
Right.
yes.
So as the Secretary argues, if there was no prior benchmark designed to remedy racial discrimination, which if you read apportionment 7 and 8, has nothing to do with racial discrimination, there can't be a benchmark for purposes of a Section 5 analysis, right?
I guess that's where I'm having trouble in the analysis, Your Honor, because I guess I would resist and tend to direct the court away from that kind of analysis, because I'm not quite following why that necessarily means it's not a valid benchmark, simply because.
Because isn't the Fair District Amendments interpreted according to federal law?
It certainly is, Your Honor. We're not disputing in this case that.
And in fact, the appellees don't even argue a Section 2 claim, correct?
They do not argue a Section 2
They argue
claim.
a Section 5 claim, correct?
They are arguing a Section 5
And a
claim.
Section 5 claim, under Section 5, what you do is you freeze a prior district that was created in order to remedy racial discrimination, correct? That's what Section 5 does, right?
Section 5 says that measured from a legally enforceable benchmark, as established in the non-diminishment standard, the state can't diminish minority voting power.
Yeah, but Section 5 has been interpreted by the Supreme Court in Beers and others to contemplate retrogression, so it's a non-retrogression or anti-retrogression type of provision. Doesn't retrogression presume that there was already a remedy under Section 2? And isn't the tension here resolved if you read it that way? So typically in a Section 2 claim, you have a district that's been designed as a remedy. It's gone through the Gingles factors. And so that you can assume that in some way that that's already been approved by a court or something under the VRA. And Section 5 is intended to lock that in place so that a state can't undercut that in a subsequent analysis.
Yes, certainly, Your Honor, and we certainly have advanced that argument to the court, that as a threshold matter, before a benchmark can be a valid benchmark, you need to run through the Jingles factors, and I don't think there's any dispute that the benchmark in this case would fail that as so construed. Just parenthetically, another way I think the court could avoid the constitutional some of the constitutional questions that we have raised is to give effect to another aspect of the Department of Justice's guidelines established under Section 5 of the Voting Rights Act. And one of the things the Department says in those guidelines is that the state is not required to diminish if it would require a gross deviation from traditional redistricting principles. And that would be another way to get there, I think.
Well, wouldn't the Duval-only district resolve that problem, though? So is there not then a conceivable district that could be drawn consistent with both equal protection under the U.S. Constitution and non-diminishment under the Florida Constitution?
No, it would not, Your Honor. That would not fix the problem, because the Duval-only district, and I don't, Mr. Norby may speak to this in more detail, but as we point out in our brief, I think certainly did diminish. The Duval-only district resulted in, instead of the black preferred candidate winning 14 out of 14 elections, it was reduced down to 9 out of 14 elections. That is a reduction in the black preferred candidates' ability to get elected, the ability of black preferred candidates to get elected. And another problem, I think, with the Duval-only district, quite apart from that, is that I do think it itself was a racial gerrymander. And to be sure, the district itself, that's compact enough, but only at the cost of creating this sort of donut-shaped hole and destroying the compactness of the surrounding district, not to mention the fact that in the legislative process, the direct evidence makes pretty clear that the motive for drawing that kind of odd district was to comply with the relatively strict racial target that the Fair District Amendments establish in the form of the non-diminishment principle. So I don't think that the Duval-only district represents a district, a counterexample to the fact that the east-west configuration of this district is the only one that anyone in the course of this litigation, where people have been litigating this very vigorously, have ever identified that would satisfy the plaintiff's legal concerns. And the problem with that is that it is a racial gerrymander. It is
given that the Supreme Court has said in redistricting 8 that it had to have an east-west district, and the governor seemed to acknowledge that in his request for advisory opinion that suggested that there would be the need under Supreme Court precedent for an east-west district, aren't your arguments better suited for the Supreme Court to overrule its precedent than trying to ask us to address its precedent?
No, Your Honor, I don't think so. I think the Supreme Court's decision, of course, we don't think forecloses that. Of course, we did ask this Court to pass this through to the Supreme Court. The Court has not done that. But I don't think that there's anything in Apportion 7 or 8 that resolves this question. I think the governor was recognizing that there is an issue there because, that there's an issue about whether the district diminishes and that there is something to decide there, and we're asking this Court to decide that.
Are 7 and 8 res judicata on the appellants?
Certainly not, Your Honor. It's certainly not res judicata. That issue, res judicata, more specifically, perhaps another word of saying it, claim preclusion, would require the causes of action and an identity between the causes of action between that prior proceeding and this proceeding. And that is completely absent, which requires there to be a common nucleus of operative fact. But we have different maps. And that means that the causes of action are definitely different. And there's a U.S. Supreme Court case that we cite in our reply brief, Lucky Brand Dungarees, that is very, that's pretty on point.
So here the appellees didn't propose the east-west district, did they? They didn't propose anything, did they? They didn't propose a remedy, right?
Well, actually, Your Honor, they have proposed a remedy. At the TI stage of this litigation, they proposed and successfully convinced Judge Smith to impose on the state, eventually it was reversed, the East-West configuration, which they've represented in their papers, was necessary to prevent diminishing minority voting strength. The East-West configuration.
But in this litigation, it wasn't like Allen, where a party presented a map and said, you have to adopt this map, not the map the legislature, well, in this case, the Florida Supreme Court ordered, right?
It is different from a Section 2 claim, Your Honor. That's true. At the same time, and I don't want to steal Mr. Nordby's thunder, who may address this in greater detail, but when the state, in a redistricting case, defends its map on the ground that it was that the plaintiff's legal demands in their suit could not be satisfied without sacrificing other higher legal principles, it is entirely consistent with typical redistricting practice to require the plaintiffs, who have the burden of proof on their claims, to establish that there is a possible remedy that the court can impose that would be both consistent with their legal demands and with the otherwise applicable legal principles the state was trying to respect. And Mr. Nordby's brief, I think, quite effectively shows that the Supreme Court did just that in Apportionment 1. And the Supreme Court, as we pointed out, the U.S. Supreme Court in Abrams versus Johnson did something quite similar, because the issue in Abrams was that the plaintiffs were upset that the court-drawn district didn't draw two majority-minority districts. There were only one. And the reason the district court did that was because it said, I can't draw two majority-minority districts without creating a racial gerrymander. And the Supreme Court said, yep, that looks totally right to us, because the plaintiffs' alternatives that they proposed that would create two majority-minority districts were all racial gerrymanders. And then the court said, and therefore the defendants win because the map holds because the plaintiffs have not shown that it's both possible to create two majority-minority districts and also comply with the Equal Protection Clause. And I see that I'm into my time.
Can you think of a U.S. Supreme Court case that has applied Section 5 independent of and separate apart from Section 2? In other words, applying retrogression or non-retrogression to a district that happened to be black performing but wasn't drawn as a remedy under Section 2? I know that's like a final exam question, but you
It's like
seem
a
well
final
versed in
exam. I regret to say that I cannot off the top of my head think of such a case, but that does not mean that it does not exist.
I understand, but but my point is, as a matter of principle, it seems like everyone's assuming that it's possible for at least under the FDA, that diminishment, it's okay to apply diminishment to a district that wasn't drawn as a remedy for racial discrimination, that just coincidentally was black performing, but wasn't drawn to eliminate dilution or address dilution.
Well, I don't think we assume that, Your Honor. I mean, I think we're contending that you have to run the Jingles factors before, which is a form of, I think, what you're saying.
Right. I mean, but you don't get to the Jingle factors. The Jingle factors, we had an internal debate as to how it's pronounced, but we went with, go ahead. I went with Jingles, but either way, the factors, Thornburg factors, to get there, doesn't there have to be a Section 2 type claim first and have that remedy be drawn up before you can get to a diminishment in a subsequent cycle?
I don't think that's quite the same as what we're contending, Your Honor, that it necessarily has to have been a district that was drawn pursuant to Section 2.
But that is a reasonable way of reading Apportionment 1 and to eliminate the equal protection challenge that's being asserted by the state, right? I mean, the plaintiffs would lose under that theory, that their solely Section 5 or diminishment claim, which is the only thing they're asserting, fails because they're unable to establish a benchmark district that was drawn up consistent with what Section 2 would expect, or to address a dilution claim.
That would certainly address the some of the constitutional considerations, Your Honor. That's correct, and that's kind of the genesis of our Jingles claim, that there's a textual link, unlike Section 2 and Section 5 of the Federal Voting Rights Act, which are sort of separate provisions in Section 20 of the Fair Districts Amendment, there's a textual link between the non-diminishment provision and the vote dilution provision, such that, it talks about, racial and language minorities, and the way you identify what those are, which minorities are protected under Section 2, is that you run the jingles factors to figure out where the minority population is. And that was what was at issue in Allen versus Milligan.
Mr. Whitaker, we need to leave time to hear from Mr. Nordby.
Certainly.
Real quickly on that, though, we're kind of in this odd place of the Voting Rights Act, and Section 5 in particular, is a penalty regime, whereas the Fair Districts Amendment, Article 3, Section 20, is just a substantive law requirement, right? It's not necessarily a penalty regime, so there's not this one-for-one type thing going on where we're looking to violations having produced a Section 5-oriented remedy.
I think that's right. It is sort of differently set up, Your Honor, and I think the fact that it is a provision of the state constitution as opposed to an exercise, for example, of Congress's enforcement power under Section 5 of the 14th Amendment is precisely why I don't think you can just sort of say that automatically compliance with the Fair District Amendments is a compelling interest in the way that the U.S. Supreme Court seems to have assumed in the context of the Voting Rights Act. I don't want to wear out my welcome. So.
Sure, yes. Why don't we hear from Mr. Nordby, and why don't we add, let's say, 8 minutes each side. Thank you.
May it please the Court, Dan Nordby and Andy Bardos on behalf of the legislative defendants. The legislature raises a slightly different argument from the Secretary here. The legislature accepts, in response to Judge Bilbrey's question, legislature accepts the premise that District 5 adopted or imposed by the Florida Supreme Court in 2016 is a valid benchmark. The legislature's different and perhaps more straightforward argument to reverse relies on the burden of proof. The Florida Supreme Court held in last decade's redistricting cycle that a challenger's burden of proof under Florida's redistricting amendments includes the obligation to demonstrate a potential remedy, a lawful alternative district configuration that complies with all constitutional constraints. The plaintiffs here failed to carry their burden on their non-diminishment claim against the enacted plan because they did not show that it was possible to draw a congressional district in North Florida that complies with both the Florida Constitution's non-diminishment provision and the federal Constitution's Equal Protection Clause.
What effect does the state's stipulation of pretty much everything, it seems, at the trial level have on your argument about burden of proof? I mean, can there be a burden of proof if the parties have stipulated that there actually are no fact issues and no evidence that needs to be disputed by, or resolved by the trial court?
Well, I think one effect of it is that this court is, in a lot of ways, similarly situated to the trial court in its ability to review the stipulated evidence and the arguments of the parties. But the plaintiffs, if the plaintiffs bear the burden and on the stipulated facts cannot establish that burden, the result of that is that the plaintiffs lose and this court should reverse.
But isn't it almost like the state's invited error on that? I mean, if the state walks in and stipulates there are no disputed issues of fact, and this is all questions of law for the court to decide, how can you then make well, the plaintiffs didn't meet their burden of proof in the appellate court?
Your Honor, if the stipulated facts that have been stipulated to by the parties are insufficient to carry the plaintiff's burden, then the result should be a judgment for the defendants. And we'd submit that that's the case on these facts.
But isn't that more of an argument of that the facts or the evidence that was stipulated to does not support the trial court's findings unless the plaintiffs did not meet their burden of proof? Like if you had an issue about their burden of proof, why not go to trial and make them prove their case instead of stipulating everything?
Well, Your Honor, we stipulated the facts, but the stipulated facts here don't establish the plaintiff's burden. The state had no concern with stipulating to a set of facts that did not satisfy the plaintiff's burden of proof. The result of that should be a judgment in favor of the defendants. And the plaintiffs here, as we discussed in our briefs, did not establish that burden of proof, their burden of proof under Florida Supreme Court precedent, to show a lawful alternative configuration that complies with both the non-diminishment provision and the Equal Protection Clause. We cited in our initial and reply briefs Florida Supreme Court case law establishing that that is their burden. They must prove the existence of a potential.
The cases that you cited, weren't they Tier 2 versus Tier 1 cases where the burden wasn't met, whereas here it's Tier 1 versus potentially Tier 0, right?
They weren't all. Some of them were Tier 2 versus Tier 1, but there were also cases involving an interplay between Tier 2 or Tier 1 and federal law. So we cited Apportionment 2, 89 Southern 3rd at 889 to 90, where the Florida Supreme Court said that challengers have not carried their burden of proof where their alternative plans, this was regarding a state Senate district, raised concerns under the non-diminishment provision of Florida Constitution and contained, quote, potential Section 2 issues. So there the Florida Supreme Court was looking to federal law, the Voting Rights Act and federal law, in determining that plaintiffs had not established their burden of proof. And in terms of the superior authority between Section 2 and Section 1 and Section 1 and 2 and what we've referred to as Section 0, which is what the Supremacy Clause requires, the analysis we submit is the same. The legislature is obliged to follow the superior tier of considerations here, and federal law under the Supremacy Clause is supreme over both Tier and Tier 2 in the event of conflict here.
Well, counsel, I'd like to go back to the stipulation. It seems that the stipulation may go beyond factual stipulations in some places, such as making conclusions about political cohesion or whether a candidate was a candidate of choice. Is this court to take those types of stipulations at face value?
We've stipulated to those facts and don't take any issue with those facts on this record here.
Are those facts? Is whether a candidate is the candidate of choice or whether a district is politically cohesive, are those fact questions or are those legal questions?
I believe those are fact questions, the way that the Florida Supreme Court has analyzed it, that those are fact questions. There's certainly an application of some legal principles to arrive at those conclusions, but we've not disagreed with those.
But the Supreme Court, in at least Apportionment 1, went into the database itself, correct? Like it made a lot of factual decisions and based on their own, review of the data. It wasn't as if, they took a stipulation that said this district is politically cohesive or this was the candidate of choice. They actually went through that record very, very carefully to reach those conclusions.
They did, and maybe I can distinguish between two separate sets of things. The data, the election results, the census results, those are certainly facts that I think are fairly undisputed among all parties here. The Florida Supreme Court in Apportionment 1, Apportionment 2, and then some of the other cases looked at those facts, for example, in conducting a functional analysis for retrogression, and examined them to determine whether there was a candidate of choice, whether a proposed district would diminish as compared to a benchmark district. So it applied those facts in that context. So to that extent, there may be some mixed questions of fact and law in some of those conclusions, but we don't dispute the stipulations that we've made.
Counsel, it seems that you're maybe confusing burden of proof with sufficiency of the evidence. So I'm having a hard time thinking of a case that says, it sets out a legal principle that whether the plaintiff met their burden of proof is a legal question. And what you're saying is that the trial court was supposed to make a legal determination whether the plaintiff met their burden of proof, and then you're having us make the same assessment as to whether the trial court or whether the plaintiff, as a matter of law, met their burden of proof.
So, Your Honor, I think the approach that the Florida Supreme Court took in Apportionment 1 and 2 is the same approach that the trial court took in the case that led to Apportionment 7. We think it's the same approach that the trial court and this court should follow here.
Well, but the Supreme Court's not a trial court, but the trial court here is a trial court. And so the trial court has to do certain things. Typically, they make credibility determinations and make findings of fact based on the evidence before them.
Well, the Florida Supreme Court in Apportionment 1 was acting essentially as a trial court of original jurisdiction. The Supreme Court's review of the validity of legislative districts is not, for example, an advisory opinion process. The result of that is a declaratory judgment. To be sure, it's an unusual declaratory judgment. It's issued on an expedited timeline based on briefing by an argument by the parties. But it's based on the sort of facts that are also stipulated to here. But to your question about whether this could be viewed as a sufficiency of the evidence, even under that framework, if this court were reviewing the sufficiency of the evidence to prove the plaintiff's claims, we still win, because the evidence here does not establish that there is an alternative district configuration that complies with the Equal Protection Clause and the non-diminishment provision. So we've laid out in our brief the version of District 5 in Plan 8019, the Duval-only district that Judge Bilbrey referenced, is a district that would diminish under the analysis that the Florida Supreme Court performed in Apportionment 1 and 2. And this is laid out at pages 14 to 18 of our reply brief. It takes a district in the benchmark plan that performed in 14 out of 14 statewide elections for the representative of choice of the black community in that district, and turned it into a district that would perform on only 9 out of 14.
Well, that's compared, though, to a Tier 0 versus Tier 1. If we say, okay, equal protection means you can't have the East-West district, right? You got to have something less, according to appellants, racially gerrymandered. So then if we're comparing then Tier 1, Tier 0 predominates, then Tier 1, isn't it not possible then with the Duval district to draw a better district with less diminishment than the current district?
Well, Your Honor, we don't think it's sufficient for the plaintiffs in attempting to prove a non-diminishment claim to offer as their remedial district a district that itself diminishes. In order to show an alternative configuration that the legislature should adopt, the plaintiffs would have the obligation to show a district that does not diminish, a district that is compact and complies with the Equal Protection Clause, but also accomplishes non-diminishment. On this record, there is simply no district anywhere that's been shown through the legislative process, through the plaintiffs' experts, other than an east-west district stretching from downtown Jacksonville into the heart of Tallahassee that actually accomplishes non-diminishment. And that's a function of where people live in North Florida. There simply are not enough voters with the demographics and partisan affiliations necessary to accomplish non-diminishment in Jacksonville alone. And this has been true for 40 years.
I mean, the legislature adopted that district, though, and they certainly thought before the governor vetoed it that it complied, right?
Well, Your Honor, that district does accomplish non-diminishment. There's no question about that. The East-West district does not diminish. The Duval-only district does diminish.
But the Duval-only district was the first district adopted in the initial apportionment by the legislature, right?
That was denominated the primary district in the plan that was vetoed. But as I've discussed, and at pages 14 to 18 of our reply brief, we lay out in more detail statistically, that is a district that would diminish. So that district cannot be a valid remedial district that the plaintiff would have an obligation to prove.
So it's not consequential that it might be less unconstitutional. It's still unconstitutional, is what you're saying?
That's right. Article 3, Section 20 does not say that plans shall be drawn not to diminish a lot. It says they shall be drawn not to diminish. It's a binary decision there. And District 5 in Plan 8019 would diminish, so it's not a valid remedial map. The Plan 8015, the East-West district, would not diminish, but it does so at the expense of every other redistricting criteria that's looked at under an Equal Protection Clause analysis. The district squeezes between I-10 and the Georgia border across the entire length of North Florida. It hooks into Duval County to the east, and on the western end, it thrusts an appendage from Gadsden County into South Tallahassee. We lay out in our briefs that it separates FSU from FAMU. It separates Southwood from most of the south side of Tallahassee. It divides Tallahassee, Leon County, and Duval County on grounds that cannot be explained on grounds other than race. The plaintiffs have never proffered any explanation in the trial court other than race that could justify a configuration of the East-West district like that.
But what you're really describing is, I mean, that's the first precondition under Gingles. And you're talking about geographical compactness and, you know, a sizable black majority, and you keep talking about diminishment. Diminishing what? I mean, it's diminishing this broadly spanning black community, or, you know, a population that stretches from Tallahassee to Jacksonville. But that's not been established as an actual, you know, compact group that Section 2 seems to anticipate. So it sounds like you, without arguing it, you're really arguing that the failure here is on the nature of the claim that the plaintiffs asserted. That they asserted essentially a Section 5 claim, and they should have asserted a Section 2 claim if they're going to claim that dilution is the problem.
Your Honor, I don't think the plaintiffs are alleging a Section 2 claim
I know
here.
they're not.
And the reason for that is because they clearly can't establish that.
I think you're right.
The legislature has not adopted the argument that the Secretary is making on the application of the Jingles factors. The Florida Supreme Court has left some questions open in its redistricting litigation. Mr. Whitaker argues with some force as to how those questions should be decided or whether there are constitutional avoidance arguments or interpretations that might be adopted to avoid some of these difficult questions. Our argument, as I suggested at the outset, is more straightforward. The plaintiffs here have the burden, and they didn't satisfy their burden. Consistent with the approach that the Florida Supreme Court took in Apportionment 1 and 2, this Court need not reach the Jingles argument or the validity of the benchmark district in order to reverse on that ground.
If you're going to keep going back to that then, and it sounds like then if you acknowledge that that's a legal argument, is whether they met their burden of proof, if we're going to deal with that on appeal in the same way, I'm looking at the stipulation and then the legal issues remaining for trial court resolution. I don't see it including the plaintiff failed to meet their burden of proof as one of the stipulated legal issues remaining.
Well,
So how is that not, at least this particular argument, not kind of coming really close to invited error?
Well, the trial judge, Judge Marsh, asked in the hearing below about exactly that burden issue. It's at page 12-251 to 12-256 of the record. It's pages 163 to 168 of the transcript. That's exactly that. Who bears the burden here, and what is their burden? And the response that was given to him by the defense is plaintiffs bear the burden. It's their burden to show both diminishment as compared to the benchmark map, and it's their burden to show that a valid remedial map could be drawn.
Perhaps this could clarify it, the landscape. First off, I'll ask, I assume there's no objection by the legislature if they prevail in this case on the basis that the plaintiffs failed to prove their case. You have no objections to prevailing, correct?
We have no objection to an argument that the plaintiffs failed to meet their case.
It seems like what is strange about this case is, again, the Florida Supreme, forget the legislative adoption of the East-West District, which you might say they did under duress. The Florida Supreme Court adopted the East-West District to remedy partisan gerrymandering. They created it. Had nothing to do with a single racial discrimination claim. Now, if there are other districts in Florida, which there are obviously, that are compact, that do perform in a minority-majority manner, such as, if I'm not mistaken, Representative Wilson's district. I believe there's a district in the Tampa area. So you have compact, racially distinct minority-majority performing districts. If the legislature attempted to change those districts, if the legislature attempted to split up what is a cohesive, compact, minority-majority performing district, then obviously the plaintiffs to challenge such a action by the legislature would have a very strong claim, correct?
Your Honor,
And the hypothetical.
I certainly agree. The North Florida district here, the District 5 imposed by the Florida Supreme Court, is unlike any other district not only in the congressional map, but in the state Senate map as well.
I mean,
no
whether,
other district
right,
has
whether
that.
or not it's a racial gerrymander or not, or whether or not it's bizarre or not, which anyone looking at it can see it's bizarre. It goes from downtown Jacksonville to rural Gaston County. At one point, it's 2 miles wide. I think, as they mentioned in one of the Supreme Court cases, you could drive a car down the interstate with both doors open and kill some voters. So, I mean, no doubt about that. But that was ordered by the Florida Supreme Court to remedy partisan gerrymandering, right?
The plaintiffs, Your Honor, in that litigation brought a partisan gerrymandering claim. They alleged that the North-South District was a partisan gerrymander. The legislature and the Secretary of State defended that district on racial minority protections last decade. And what the Florida Supreme Court said in Apportionment 7 is that the partisan intent issues could be addressed with the adoption of an East-West district that would, the Supreme Court concluded, not diminish as compared to the prior North-South District.
Is there any
and Your Honor,
evidence?
I apologize. I don't know if this has the added 8 minutes that the Chief gave us or not.
I think that it does, but why don't we let Judge Tannenbaum ask his question, and then we can figure out the clock.
Is there any evidence in the record showing that there historically in the Jacksonville area, or we'll say even the Tallahassee area, either one, whether there was historically a vote dilution issue that needed to be remedied?
In a congressional district, I believe the answer is no. I can't speak to local.
And I'm
local
sorry, I should have
districts.
limited, and that's what I meant. I meant congressional, on a congressional map, yes. Okay, thank you.
Thank you. And why don't we add, let's say, 4 more minutes to each side.
Thank you.
Thank you.
Good morning, Your Honors, and may it please the Court. Jyoti Jasrasaria on behalf of Plaintiffs' Appellees, and I'm joined by my colleagues Julie Zuckerbrod, Fritz Wormuth, and Quinn Ritter. Your Honors just heard 2 sets of appellants invoke multiple federal legal doctrines and try to complicate the issues before this Court in order to cast aside the plain language of the Florida Constitution and the clear command of Florida precedent.
How is that plain language to be, how is that plain language to be interpreted?
The Florida Supreme Court has been very clear that the non-diminishment provision bars the state from adopting redistricting plans that have the purpose or will have the effect of diminishing the ability of any citizens on
I
account
think
of
the answer
race.
is it's to be interpreted according to federal law, correct?
It is to be interpreted according to federal law, and the Florida Supreme Court has said that just like federal law, the non-diminishment and the non-dilution provisions provide 2 dual mandates that are separate and have separate legal requirements.
Has the Florida Supreme Court or any other Florida court addressed this issue in the context of equal protection, an equal protection argument like has been raised here?
The Florida Supreme Court has held and dictated that the structure of the Fair District Amendment does not give the legislature any opportunity or mandate to racially gerrymander. So in that way, yes, it has looked at the Fair District Amendments itself and held that they can be applied consistently. It has not faced a claim exactly like this one, but I think in many ways that just underscores how procedurally improper this particular affirmative defense is. Because
And under federal law, Section 5 of the Voting Rights Act freezes a remedy enacted pursuant to Section 2 of the Act, correct?
No, Your Honor. The Section 5 provides a separate mandate to protect any district
It prohibits retrogression from a Section 2 remedy, that is, a compact, cohesive minority-majority performing district, correct?
That's not correct, Your Honor. The Section 5 has a separate analysis, the functional analysis, which is something that the Florida Supreme Court has adopted.
But what does Section 5 address?
Section 5 protects any district in which the minority population is cohesive and in which the minority population's candidate of choice prevails in both primary and general elections.
And is reasonably compact.
There's no compactness requirement built into the Section 5 analysis.
Is it your argument that under Section 5, a plaintiff could prevail in a case defending a non-compact, bizarrely drawn seat that was ordered by a state court?
Well, here, luckily, that's not the position we have here. We have the Florida Supreme Court has approved the benchmark CD5. It is a district that complied with both Tier 1 and Tier 2, including traditional redistricting criteria of the Florida Constitution. And so it's certainly the proper benchmark. It's never been invalidated. And so under both federal and Florida law, it is the proper benchmark for this court and for the legislature to consider, which is exactly.
Even though it had nothing to do with remedying past racial discrimination.
That's correct, Your Honor.
It seems to be begging the question then that talking about a benchmark district, the only reason it's a benchmark is because it was adopted in some way and coincidentally was a black performing district. What is it wasn't adopted though as a remedy for racial dilution in some way. And so I'll ask the same question that I asked opposing counsel. Is there a U.S. Supreme Court case that involves the application of Section 5 of the Voting Rights Act, separate, independent of Section 2 remedy. In other words, Section 5 preserving a coincidentally black performing district, but not one drafted specifically to remedy vote dilution under Section 2.
Yes, so Section 5, the majority of those cases are exactly in the posture that you just mentioned, which is that they do not, they're not related to a Section 2 claim. They are a separate Section 5 claim to ensure that a district, regardless of whether it was adopted as a remedy to a particular non-dilution violation or not, but that any district, regardless of whether it's a majority-minority district, but indeed whether it's a historically performing district,
So
whether that
do you
district-
have a U.S. Supreme Court case that addresses a situation, a covered district under Section 5, where they didn't have a pre-existing set of districts that was a remedial plan, where it coincidentally was a black performing district, where that covered district was affected by, or Section 5 applied to them separate and apart from Section 2?
I can't name a specific case, Your Honor, but my understanding is that all of the major cases dealing with Section 5 treat Section 5 completely separately from Section 2.
Well, what is your understanding of Beer then when it describes the purpose of Section 5, freezing in place the gains that a minority group has made already? What do you think the gains what do you think the Supreme Court is referring to when they talk about gains? Take into consideration the history of the Voting Rights Act and what the Voting Rights Act was adopted to address in the first place.
Well, I think this case provides a good example of that because up until 1990, there was no black elected representative from North Florida sent to Congress. And
But that's not a
this is
basis
the
for a
first-
constitutional claim, right? In and of itself. That's not particularly relevant.
Well, I think it's relevant in that, now for the first time, we don't have a black representative from North Florida in Congress. And it shows that
But you didn't bring a dilution claim, right?
we didn't bring a dilution claim because we didn't have to. The benchmark district is the last legally enforceable district. And even before this benchmark, there was a historically performing district for black voters.
Let me ask
and
you, maybe a
voters.
hypothetical could help. Let's say the legislature decided to enact 14 minority-majority performing districts in Florida. Lots of snakes, north, south, east, west, diagonal, lots of totally bizarre, sort of like the East-West District, totally non-compact districts, but the legislature in its infinite wisdom decided we want 14 of these kind of districts. Then the next legislature decided that that's contrary to sound redistricting practices, likely violates the Equal Protection Clause of the United States Constitution. We're going to redraw those lines in a more compact manner. You might end up with 3 or 4 minority-majority performing districts. Is there a fair districts claim on those other 11?
Well, I think that, it's an interesting hypothetical, Your Honor. I'll say that in the first instance, if the legislature were to enact 13 or 14 districts that don't comply with any traditional redistricting criteria.
We'll call them snakes.
Sure. If they enact some snakes, then we will be in the position where those districts could not be protected because of, they would not be compliant with the Florida Constitution itself. But here, that's not the situation that we have because the East-West District that was adopted by the Florida Supreme Court carefully went through and said that it was visually and statistically more compact than other options it had considered. And as the trial court made clear
Not
findings.
a model of compactness, as they said.
Sure, not a model, but still complies with
Downtown
compactness.
Jacksonville, by I-10, 2 miles wide to rural Gaston County. That was the district ordered by the Florida Supreme Court. Why was it ordered, by the way?
So the Florida, as you mentioned, in speaking to my friends on the other side, the Florida Supreme Court adopted that district in order to remedy a partisan gerrymandering
Well, what if
violation.
the Florida Supreme Court ordered 14 snakes? Let's say they interpreted the Fair District Amendments, hypothetically, of course, and they ordered 14 minority-majority performing districts, snaking all around the state of Florida. Now, all bizarre. And the legislature in the next session, or the governor, said that's absurd, it's racially discriminatory, we're not going to do that. we're going to reduce those 14 to 3, as my prior hypothetical said, do you have a fair districts claim on the other 11? And if not, how's it different than this one?
Well, I think that, under the clear test of the diminishment claim that the Florida Supreme Court has adopted, then yes, if the Florida Supreme Court had adopted a map and it was legally enforceable and it protected minority groups' ability to elect their candidate of choice, then yes, there would be a claim. Of course.
But isn't there more here? I mean, assuming these snakes were, adopted, approved by the Supreme Court, it's not even that they're legally enforceable, it's that they were used, right? Under your argument, that then becomes a benchmark. And, to pick up on what Judge Tannenbaum's saying, they're generally, and again, I hope that maybe even supplemental briefing, you'll show us a U.S. Supreme Court where there wasn't a Section 2 violation. And I point you to Allen v. Milligan, which talks about, it's not just enough that you had, no minority elected, as you've argued. In fact, it's that the law, practice, or structure interacts with social and historical conditions to cause an inequality in the opportunities enjoyed by black and white voters. And there's no evidence in this record, not just a legal argument, but there's no evidence in this record that this district meets that criteria, is there?
Well, there is racially polarized voting in this district. That's been stipulated. And so we know that black voters and white voters in North Florida vote for different candidates.
Is that true? Did black and white voters vote for different candidates in Leon County? Because as I recall, they did not.
So across the district, this is part of the stipulation. And,
Did black and white voters vote differently in Leon County is my question.
I can't speak to Leon County in particular, but across the district, yes. Across North Florida, all the, obviously there cannot, Leon County itself is not large enough to be a congressional district. And so in the area that would comprise the district, there is racially polarized voting between black and white voters, and that's been stipulated.
Can I ask you, were the plaintiffs below required to prove a potential remedy? Is that something that you needed to say, this is this district that's currently in place doesn't comply because of non-diminishment? Here is a district that does, and Judge, you should adopt this or have the legislature adopt this.
No, Your Honor. So the plaintiffs were not required to do so under Florida Supreme Court precedent. The only thing they're required to do is establish liability here, which has essentially been stipulated to by all the parties. And as this court itself said last year, it's for the legislature to take the first bite at drawing a remedy, and so plaintiffs certainly are not required to. But I will say that here, plaintiffs and the trial court itself did decide, made factual findings that Plan 8015 and Plan 8019's CD5s are compliant with traditional redistricting criteria, and that race did not predominate in the drawing of those districts. And we have the legislature itself saying last year when it passed those maps that those maps, as you mentioned, are, the primary and secondary map comply with all of the requirements that they were under. And so it is certainly not for plaintiffs to provide a map, but here we have two such maps that the trial court has found are compliant.
What's the distinction between an unlawful racial gerrymander and a racially conscious district? Is there something that gives us a clear understanding of where to draw the line?
Yes, so I appreciate the question, Your Honor. The race consciousness and racial predominance are there is a line there, and it's because race predominance is a fact-intensive, demanding, difficult inquiry. Those are all words that the U.S. Supreme Court has used to describe it, because race predominance means that race alone was the motivating factor to the detriment of other criteria. And it doesn't mean that, race was just something that that the map makers were conscious of. In fact, we have in Allen versus Milligan that was, decided just this summer. The court says that even intentionally drawing a majority-minority district is not racially predominant, as long as other considerations are being taken into account equally.
Well, Allen was a dilution claim, right? So does that apply to a diminishment claim?
Yes, so the racial gerrymandering claim is separate and apart from any Section 5 or Section 2 claim. It's a completely separate claim that just asks whether the map makers were taking race as a primary motivation to the detriment of other considerations in drawing a map. And so that framework of racial gerrymandering can be applied to any map, regardless of whether, it's trying, maybe the justification that's being asserted is Section 5 or Section 2. So here, in making their federal racial gerrymandering claim, appellants are ignoring large swaths of that doctrine. They are not focusing on any kind of specific district. Here, they're talking about a hypothetical remedy, and it's hard for us to prejudge what the legislature might do in drawing a remedy. For the legislature itself to say that race will predominate seems like a very odd thing to say.
But is it all that odd? Because it seems like that's what your case is, racial diminishment case, and the trial court offered you a remedy that says, basically, go draw these lines so that we deal with the race issue. So it seems like under racial predominance standards that that's where we are. We're going to go draw a map that specifically is targeted at putting aside Tier 2 and all these other things that are the general redistricting criteria. We are going to target race and go draw some lines going forward.
Well, the jurisprudence about federal racial gerrymandering makes clear that compliance with an anti-discrimination law, like the non-diminishment provision, is not in itself race predominance. And in fact, here with Plan 8015's CD5, the trial court found that, sure, it complies the non-diminishment violation, but it also performs exceptionally well on multiple traditional redistricting criteria, including adherence to traditional political boundaries, where it performs better than every single congressional district in the state, save for one. And so you see here that that district clearly was taking multiple things into account, not just race, in order to draw the district. Including that, Florida actually has a history of drawing long districts on the northern border, whether or not those were ever minority protected districts. We saw, for example, in 2002.
So are you saying that this district is, that this benchmark district, as it's been referred to, is actually a compact, geographically and sufficiently large, addressing a sufficiently large demographic group? I mean, just looking at the map, I mean, you can take a look at that thing and see what it looks like. Are you trying to tell us that these snakes, as it's been described, these appendages are all actually very reasonable?
Yes. I mean, I think what I'm saying is that the Florida Supreme Court, in drawing benchmark CD5, went through an analysis and said that the district was compliant with traditional redistricting criteria, and then you have a trial court finding the same, and that actually Plan 8015's CD5 in particular, which is something the legislature itself passed, complies exceptionally well on certain redistricting criteria. And so Florida obviously has a long northern border. It's a little bit of an oddly shaped state, and so it's not surprising that there's...
It's interesting in the Senate redistricting cases, I believe it was apportionment 1, if I'm not mistaken, or 2, the Florida Senate had adopted districts in the Western Panhandle that were east-west, northern tier districts. They argued that these were valid under the Fair District Amendment because the coastal communities and the northern, more rural agrarian communities had different interests, and therefore they were justified on that basis. The Florida Supreme Court disagreed. It invalidated those districts and said you can't have east-west state Senate districts along the corridor, that you have to have compact districts. And it ordered the Florida Senate to eventually adopt more compact districts in North Florida that did not have east-west northern tier configurations. Do you find that somewhat odd in terms of the east-west district you seem to favor here?
Well, Your Honor, I think the Florida Supreme Court speaks for itself here. It adopted that district. It explained that that district complies with the criteria that are under the Florida Constitution, and so it's certainly not for plaintiffs
for partisan gerrymandering. Let's not forget.
Sure. Yes. Exactly.
That case had nothing to do with racial discrimination. In fact, Representative Corinne Brown strongly opposed that decision by the Florida Supreme Court, which took away her district and just changed it to an east-west configuration to diminish the ability of one party to elect more congressmen or women, correct?
Exactly. So as you say, that district was not drawn for racial purposes. It was drawn to remedy a partisan gerrymander.
So how can it be a Section 2 type remedy that Section 5 of the Voting Rights Act protects?
Well, the Florida Supreme Court, in enacting benchmark CD5, did say that part of the reason it was doing so was to comply with the non-diminishment provision, because historically there had been a district that performed for black candidates of choice in North Florida. And so even though the primary purpose for enacting that district was to remedy a partisan violation, the Florida Supreme Court has in its record that part of the reason that it needed to protect that district for black voters was because of the historically performing district and the non-diminishment provision.
It wasn't protecting a district, it created a district. There was no east-west district.
There was no east-west district,
Right.
but there was a district in which black voters could elect their candidate of choice in North Florida.
Sure, but in terms of North Florida, is there a politically cohesive, geographically insular minority group in North Florida that you can identify? And where are they located? Is
Well-
it Jacksonville or is it Tallahassee?
Well, the non-diminishment provision doesn't require that the jingles preconditions to be
Well,
satisfied.
and so getting back to your original position where you started, you talked about the plain language of Section 20. It seems that Section 20 actually has that baked in when it talks about the ability of a minority to elect a representative of their choice. That bakes in to it this Section 2 type analysis that Jingles addresses, and that's the starting point of Jingles. It's not just a class of black voters wherever you find them, which is, it seems to be, that's what CD5 is it's hunting for enough black voters to create a district. It seems that Jingles in Section 2 in the Voting Rights Act generally, the point of all that, the point of dilution, is to prohibit the diluting of a discrete, geographically locatable minority group that has voting power by its very nature of where they're located. So so even on your initial premise that, well, it's plain and so it's diminishment and so we just talk about if there's a black performing district and it's eliminated, then we win. I don't see that, and can you help me with what you're looking at in the text and what the Supreme Court's talked about, what the U.S. Supreme Court's talked about, and what
Sure.
Jingles talks about?
Yeah, absolutely. So first, the Florida Supreme Court has held that the legislature cannot eliminate majority-minority districts, so that would be districts with over 50% of a minority voting age population, or weaken other historically performing districts. And so just in the plain language of the Apportionment 1 decision, the Florida Supreme Court makes clear that it's not taking that 50% threshold numerosity requirement from Jingles.
Sure, and in that particular, so in Apportionment 1, was that even an issue in Apportionment 1? Like, or is that just dicta, like that part of the discussion?
Well, Apportionment 1, the Florida Supreme Court was going through and explaining the standards for all of these, and it has used the exact same standard in evaluating actual state legislative districts, for example, just as recently as last year. And in practice, the Florida Supreme Court has protected multiple districts that have less than 50% of a population, including just last year, the Florida House argued to the Florida Supreme Court that any suggestion that the non-diminishment standard incorporates the Jingles prerequisites would directly conflict with U.S. Supreme Court precedent and would eliminate the line between vote dilution and non-diminishment. And this is how the legislature understands the law, it's how the legislature has applied the law, and it's how the Florida Supreme Court has applied the law. And so the other thing I'll note here is that
But if dilution and diminishment, I mean, it seems that the opposite is true. So if diminishment means what you're saying it means, then there is really no meaning to dilution because they're the same thing, even though the Florida Supreme Court has said that they're different. So if retrogression, I'm assuming you agree that retrogression and diminishment are the same?
Yes, I agree that retrogression and
Those
dilution are the
terms
same.
are
Exactly.
referring to the same
Yes.
problem. And dilution is a separate problem.
Correct.
Right? I mean, the dilution does not appear in Section 20, but we understand it as two separate analyses, right?
Right. well,
Dilution and retrogression.
Exactly, and Section 20 does have both standards.
Right.
Yes.
But it seems that what is being protected is a a particular type of voting block, not just minorities generally, or, black voters generally, wherever you can find them, to make a district that you want. It's a specific remedy to address a specific problem, and that is discrimination. So how is it that retrogression, if it's a retrogression claim, it doesn't presume that there exists a district or a group of voters that would meet the Jingles test?
Yes, well, some of the Jingles factors are incorporated into the retrogression analysis. So one of those is cohesion. So we do have here a minority group that votes cohesively. And we also have racially
But
polarized
it's only because
voting.
it was drawn to include a bunch of voters that voted a certain way, not because that particular geographically compact group happened to vote a certain way. They vote a certain way because the Florida Supreme Court manufactured it that way, right?
Well, the Florida Supreme Court drew this district and, again, said that it complies with traditional redistricting criteria, and even though it's not a model of compactness, that it's visually and statistically compact. So I think that, it's certainly not for appellees or for this court to question the Florida Supreme Court's approval of benchmark
Why not?
CD5.
It's acting in a political capacity when it's drawing a district, which is the same as what the legislature typically would do. So why isn't it fair to question what the Supreme Court did in a prior, when it was enacting or approving the enactment of, or a court-drawn set of districts?
And the issue here is completely different, right? The issue here, excuse me, the issue here is you're arguing that this is a benchmark and that it can't be diminished. That wasn't the issue in apportionment 7 and 8. It was a partisan gerrymandering claim. This is a completely different case, correct?
This is a different case.
So it's
but-
not binding precedent that bars this court from holding you can't establish a benchmark because that district wasn't drawn to remedy racial discrimination. This is a different legal question, correct? I'm not saying you lose, but it's a different legal question, right?
It's a different legal question, but
Right.
I'll say that the benchmark analysis does not require the benchmark to have been drawn to remedy racial discrimination. It simply
You don't
requires.
think that's true under federal law?
That's not true under federal law.
Where do
Tell
you
me
get that
again,
from?
then tell us the case where the U.S. Supreme Court has said that we're just going to say that the Voting Rights Act means you can never change a district that happened to perform in a minority-majority manner. Because that's certainly not the case in Allen, the Alabama case.
Exactly.
Those were compact. The Chief Justice Roberts, writing for the court, went to great lengths to note these were compact, minority-majority performing cohesive areas. This was not a snake in Allen that the court ordered or protected, right?
Absolutely. And Allen was a Section 2 case in which the plaintiffs, who I was lucky enough to represent, were challenging.
Well, congratulations.
Thank you. The plaintiffs were challenging the fact that there was no district there. But here.
I mean, that's totally different than this case, isn't it? I think it's wonderful that you represented the parties there. This is a completely different case. This is a bizarrely drawn district enacted by the Florida Supreme Court, imposed on the legislature to remedy partisan gerrymandering. Representative Corinne Brown in the wings argued, no, my district is fine. And they said, no, that's too favorable to Republicans. We're going to create this East-West district, which, by the way, because we're drawing it 200 miles long and capturing all these black voters, will perform in a cohesive manner. That's what happened, right?
That's what happened. And the clear test under both Florida and federal Supreme Court law is that any district where the minority population is cohesive, where there's racially polarized voting, and where the minority population's candidate of choice is successful in primary and general elections is
To quote
protected.
an old movie line, I don't think that word cohesive means what you say it means. Cohesive can't mean the voters 200 miles apart vote the same way, can it?
Well,
That's not logical, is it?
Well, it's logical in
Nor
that.
is it the meaning of the word, is it?
Well, the law is clear that the cohesion analysis is done on the voters that live in the district. And here, again, the Florida Supreme Court adopted this district. And one thing I'll note is that appellants here have never argued that the population, that there's a, population sparseness or something that doesn't allow the non-diminishment provision to apply, or that the functional analysis doesn't result in the need for a district. They actually did that with respect to CD10 this cycle. They decided that that district, which is based in the Orlando area, is no longer protected because it no longer meets the functional analysis. But they have never made that claim with respect to CD5. And in fact, their only quote unquote defense is that the non-diminishment provision itself doesn't comply with the federal constitution. But in
Well, they also, at least the Secretary of State did it in a few pages at the end of their brief, that actually the alternative is it doesn't meet jingle factors, in which case you don't have a benchmark that is usable for purposes of a Section 5 claim.
Sure, and that jingles analysis, though an interesting one, is not one that it's directly contrary to Florida Supreme Court precedent, which lays out.
Which part of a Supreme Court decision does that conflict with?
So in apportionment 1, the Florida Supreme Court said that you cannot eliminate or weaken other historically performing minority districts in addition to majority minority districts.
And counsel, I'd like to pick up exactly there then. What elements of CD5 make it a benchmark district? Is it simply its existence, being unchallenged, and being used in 3 cycles where minority candidates were elected? Is that enough for it to be a benchmark within the meaning of the law?
Yes, exactly. So both federal and Florida law are clear that the benchmark plan is the last legally enforceable plan, and there's no dispute that the benchmark plan was legally enforceable in 3 elections, as Your Honor mentioned.
Well, it was unchallenged on racial grounds, right? That's different than saying it was legally enforceable, is it not?
Well, the federal law, so there's in both
Which one? Which federal law? Can you
So in
specify?
Abrams versus Johnson, 521 U.S. 74, and Clark versus Putnam County, 293 F3D 1261, which is an 11th Circuit case, and the DOJ.
So not a U.S. Supreme Court case.
Oh, yes, but sorry, Abrams v. Johnson is a U.S. Supreme Court
Right, and
case.
what did I don't, I'll,
Of course.
you're answering Judge
Abrams
Rowe's
v.
question. I don't
Johnson
want to.
says that a district needs to be formally declared and found to be unconstitutional in order for it to be an invalid benchmark. And so here, there's not been a finding that benchmark CD5 is unconstitutional, and for this court to do so now would be engaging in a moot inquiry. But
Well, the governor thought it was unconstitutional.
the governor thought it was unconstitutional.
And he vetoed it.
So the governor was vetoing.
I would say that's an action showing it's not legally enforceable,
So the governor vetoed Plan 8015 CD5.
which is almost identical to the East-West District.
Exactly. Yes, it is almost identical. But under Florida, under the separation of powers doctrine, right, the governor is not authorized to declare something as unconstitutional. And in fact, the governor
the Supreme Court's not
governor didn't
authorized
take
to
an
do
oath to uphold the Constitution?
he did, and under Florida, binding
And
Florida.
so does every member of the legislature?
Exactly, but under binding Florida precedent, it is the oath to defend the Constitution is to defend the Constitution as interpreted by the courts. And the governor acknowledged as such when he sought an advisory opinion from the Florida Supreme Court last year, asking for a decision about whether the district in CD5 complies with, is necessary to comply with the non-diminishment provision. And the Florida Supreme Court said in no uncertain terms that it was not going to take that question up because it wanted to do so in the normal course of litigation. And so at this point in time, the Florida Supreme Court precedent is still the precedent. And the governor knowingly was defying that precedent in making his judgment, which...
In which way was he defying precedent? I mean, was there any legal determination by the Florida Supreme Court that this district was not racially gerrymandered? Is there any finding? Please point us to it.
Well, I'll point you to the fact that the Florida Supreme Court made clear that the reason it was adopting that district was to remedy a partisan gerrymander. And so it was not making that... there's nothing in the record to suggest that the Florida Supreme Court, that race was predominating.
So why wasn't the governor's position on terra firma with respect to the U.S. Supreme Court decisions, which have been very conscious of equal protection issues and other in the context of voting rights cases?
Well, when the governor made his vetoed the maps, one of the things that he said was that he anticipated that the Allen versus Milligan case would get rid of the line between race consciousness and race predominance. But the Allen versus Milligan case did no such thing, and in fact upheld that long tradition that compliance with an anti-discrimination statute or law is not on its face a problem under the Equal Protection Clause. And
But
so
There is no
Again, this
compliance
district-
with the racial discrimination law here.
Well-
That's the point, is that CD5 is not compliance with the racial discrimination law. So there's nothing to really analyze under Section 5, under any of the analysis that you cited.
Well, under binding Florida Supreme Court precedent and the test that the U.S. Supreme Court and the Florida Supreme Court have been using, benchmark CD5 does comply with the non-diminishment provision, and
It's
that's
so
not
clear and
disputed.
straightforward like that. Why reference the VRA at all? Why go through all the trouble, the pages that Justice Periente wrote on this question, and then citing it and saying we're going to look at U.S. Supreme Court precedent, we're going to look at DOJ guidelines, we're going to do DOJ enforcing for the DOJ. Why go through all that trouble if it's just so clear? It's like, look, if you have a district that's eliminated because it's black performing and it's eliminated, then plaintiffs win and the state loses.
Well, it is an extremely simple test, and I'll say that
But it isn't, because if once you start incorporating the VRA and the decades of Supreme Court decisions that interpret it and apply it, it's not straightforward and simple at all. I mean, there's a variety of factors, there's nuance to it, and why do you think the Supreme Court would, cite all that and then bring it in as part of the analysis if it's just easy enough to just say, we look at a district, we look at, here's the population, here's how they perform, and if it's changed, then plaintiffs win.
Well, there does need to be a functional analysis, and so that test does have is multifaceted. It includes an analysis of the population, how that population
And
votes,
we looked at U.S. Supreme Court decisions because the Florida Supreme Court said so.
Right.
We looked to U.S. Supreme Court decisions to, add that gloss to what the VRA means, right?
Exactly, and here there's no dispute. None of the parties are disputing that under the enacted plan, there was a district under the benchmark plan, there was a protected district that complies with that under the functional analysis.
Who stipulated to
performs.
being a protected district? Protected, you mean protected under what?
So the parties stipulated that under the parties stipulated that the previous plan included a North Florida congressional district in which black voters were able to elect their candidate of choice and each component of the functional analysis.
But the North-South district was never shown to be a remedy for dilution either, right?
I don't think that the North-South district was enacted as a remedy for
Right.
dilution, but
And there's no evidence that there was a dilution problem in either the Jacksonville area historically, speaking in terms of congressional districts, in the Jacksonville area or the Tallahassee area. Is that right?
I'm not aware of any, but again, I'll say that the Florida Supreme Court has made clear that these are two separate requirements, and that tracks with the way the federal courts have implemented Section 2 and Section 5. These are dual mandates with different requirements, and
Sure. But what is the purpose of the VRA? I mean, let's just talk basic. What is the purpose of the Voting Rights Act?
yeah, the purpose of the Voting Rights Act is to
Prevent racial discrimination
exactly
in voting, right?
Yes.
Okay, so doesn't that presume that there's discrimination in the first place that's being remedied?
Well,
Right?
I think that that's exactly what was happening here, is that
Has there been a showing of that? I mean, now you're equating one with the other. And typically, in a Section 2 claim, you'd have to prove all that.
sure, and
You're trying to
here-
circumvent all of that and just get to the answer without having to show discrimination.
Yeah, and that's what the Florida Supreme Court's test says, right, is that here, showing that the minority group is cohesive and that there's racially polarized voting and that the minority group's candidates are able to win in primary and general elections, that's enough to protect a district. And there's no dispute that those factors are being met here. And so this is the law as it is, and this district is protected under that law. And
Well,
again,
so when you keep talking about this is the law how it is, this is the binding precedent, but again, the Florida Supreme Court or any other Florida court has never addressed at least with regards to the equal protection challenge, has never addressed this equal protection challenge or how to properly interpret the Fair Districts Amendment in light of an equal protection challenge?
Well, the trial court in this case did find that, Plan 8015 CD5, Plan 8019 CD5, and the benchmark CD5, that race does not predominate in the drawing of those districts, and that they are remedies that, they're districts that comply with both the Florida Constitution and the federal Constitution.
And so that's what we're here reviewing, right? So
Exactly.
when you're talking about binding
Sure.
precedent for us, whatever that might mean, there isn't anything, right? I mean, there's nothing that has discussed this equal protection issue in light of the Fair Districts Amendment.
So again, the Florida Supreme Court has said that the structure of the Fair District Amendments doesn't require any kind of racial gerrymandering. And again, racial gerrymandering is a fact-intensive inquiry. That's what the U.S. Supreme Court has held. And here, we are talking about a hypothetical district. There's no district that's being challenged by defendants except for any potential remedy. And as Judge Bilbrey pointed out, the legislature passed 2 maps last year that it said complied with the Florida Constitution and with the U.S. Constitution, Plan 8015 and Plan 8019. And so it's the legislature's job to draw a district that complies. And the legislature did so last year, and it can do so again. And the trial courts found that those districts comply with all the requirements that are necessary. So I think that here, one of the challenges of this case, which is obvious based on the questioning here and the arguments that the appellants have made, is that this equal protection question is entirely premature at this phase of the litigation when we have...
In fact, we don't even have to get to it if you can't prove a valid benchmark, correct?
Well...
in other words, if you failed as a matter of law in the first instance because there's no district that was drawn to remedy racial discrimination, there's no need to get to the equal protection question, correct?
So the only legal question that's left in terms of the diminishment claim that was preserved below is whether the jingles factors are necessary to establish a non-diminishment claim. And the binding precedent of the Florida Supreme Court says the answer there is clearly no, and the legislature agrees.
Okay, let me try it again. I'm not asking you to concede, but if you did not prove as a matter of law that there was a district drawn to remedy racial discrimination, then there is no valid benchmark, and this court, and as a matter of law, cannot get to the equal protection argument, correct?
That's not correct, Your Honor, because there's no requirement that the benchmark had been
It's a
drawn.
hypothetical. I'm not asking you for a concession.
Sure.
But if the district CD5, I'm not going to call it a benchmark if it's not necessarily a benchmark, if it was not drawn to remedy racial discrimination, and therefore there cannot be a valid benchmark to make a Section 5 / non-diminishment argument, then the claim fails and we don't get to the equal protection clause, and we don't need to reach the constitutional dimension, right?
No, Your Honor, because there's no requirement that the benchmark in any hypothetical be drawn to remedy a racial.
So then we're back to the 14 snakes. Then if the legislature draws 14 snakes and a subsequent legislature and a subsequent governor say, wait a minute, this is problematic, we're going to redraw those districts into a more compact fashion, maybe reduce the minority-majority performing districts to 3. They can't do that under your logic.
Well, there are a couple ways that they could do that. One is if they were able to show using facts that those districts were drawn in a way in which race predominated, which we don't have that record here.
They were drawn in a way, they were drawn by the legislature in the hypothetical in a way to ensure that race predominates.
Yes, and then someone could bring a claim to show that race predominated in the drawing of those districts such that those were racial gerrymanders. And here, we don't have that kind of evidence, and instead we have the Florida Supreme Court and the trial court saying that benchmark CD5.
Well, that leads to an interesting question, which I think the appellants have brought up. But so your argument is the Florida Supreme Court did not use race as a predominant factor in drawing the East-West district, correct?
Correct.
Then how is it a district drawn to remedy racial discrimination?
It's not, and it doesn't have to be. It's a district that was drawn to remedy a partisan violation,
Right.
and it was also drawn to protect a historically performing district for black voters in North Florida.
There was no evidence that it was an historically performing black district. It was drawn strictly as a substitute for the North-South District of Representative Corinne Brown that the Florida Supreme Court eliminated, correct?
So the Florida Supreme Court said that there had always been a historically performing district for black voters in North Florida, and that...
Well, when you say North Florida, that's kind of a big phrase. Do you mean Jacksonville? Do you mean Leon County? Do you mean Walton County? Do you mean Escambia County?
Well, I'm just using the words that the Florida Supreme Court said, which is
Sure, it's loose language because they weren't focused on that. And so it sounds like you're arguing it's a one-way ratchet under the FDA. For whatever reason, if the Supreme Court gets to draw a district to address one thing, and it has palliative effects for a black voting population or Hispanic voting population, that the legislature, for time forever, the legislature is precluded from altering that. Is that the position?
Not at all, Your Honor, and that's because the functional analysis builds in a backstop and makes sure that any district that's being protected actually meets a number of factors, and those factors
But for the
are...
district to be protected, it has to have remedied some discrimination in the first place. Not just it's a noble goal for the Supreme Court to want to create a historically black performing district of some sort, but that wasn't required. That's not what they were addressing or trying to remedy. So I don't understand. Again, you're relying on the FDA, which then incorporates the non-discrimination cases and the precedent of the U.S. Supreme Court interpreting the VRA to protect a district that wasn't drawn to remedy discrimination, to preserve a performing district, and then to get around having to address, well, there's only one explanation for how this district is drawn, and that's race.
Well, I'll say a couple of things to that. So first is that the Voting Rights Act was certainly meant to remedy discrimination, but also to ensure that minority groups have equal voting power, and that is what the retrogression or diminishment provision is meant to
the group
protect.
statewide? You're talking about the voting power of black voters statewide?
So
That can't be the case, right?
Right, and it's only applied in places where you can...
Where the precondition one of jingles typically would apply, which you were running away from because you know that you can't establish that, right?
Well, again, it does not require the meeting of Jingles 1. It only requires the meeting of the Jingles 2 and 3, which are the cohesion provision and the racially polarized voting provision. And here, we meet those, and we know
but
that
without the geographic compactness, you basically open up the entire state. The world is your oyster. You just pick and choose the number of voters that you want to get to a particular end. That is the main purpose of the first precondition of jingles, is to rein that in. You have to have, it's not a general population, which is somewhat insulting to suggest that a minority, a community of black voters statewide all vote the same way. I'm sure that's not what you're arguing, but that is the impact of that if you don't have the geographic compactness associated with it.
Right, so a couple things there too. So first, the Florida Supreme Court found that benchmark CD5 met any compactness requirement. Again, not a model of compactness.
When I say compactness, I'm talking about precondition 1 under jingles. So I'm trying to use sort of paraphrasing, but I'm talking about precondition 1.
Sure, and precondition 1 does not have to be met under the non-diminishment provision, and the reason for that, it kind of makes sense, right? Here, we're dealing with an existing district that's being protected. And so the existing district provides the starting point. When you're drawing a brand new district under Section 2 or the non-dilution provision, it makes sense that plaintiffs have to show that you could have a majority-minority district and that they could be comprised in the area that looks like a district. But here, we're starting with a district, and that district in this particular case has been approved by the Florida Supreme Court. And again, even if we were to invalidate this benchmark for some reason, which, our brief outlines all the reasons that you shouldn't do that, but there was always a historically performing district for black voters in North Florida. And so...
Can I ask you about that?
Sure.
If the East-West district is an equal protection problem, and we, contrary to, reapportionment 8, find that it's unconstitutional, The Duval-only district apparently has more diminishment of voters. Would that be an acceptable substitute for the East-West district? Or because it diminishes voters more than the East-West district, is it an unconstitutional problem?
Well, first of all, the constitutionality of the Plan 8019 Duval-only district is not before this court, and it will be the legislature's job to draw a remedy. The legislature said last year that they thought that Plan 8019 was compliant, that it was a reliably performing district for black voters. And of course, going back to what Judge Tannenbaum said, there is a multifaceted analysis that needs to happen in order to determine whether a particular map is compliant with the non-diminishment provision, which is the functional analysis. And so even though we have some quotes from the legislative record showing that there may be some elections in which black voters candidate of choice did not perform under the Duval-only district, that's not something that's been stipulated to. It's not findings of fact that have been made under the full record of looking at all of the elections, including the most recent elections in 2022, and looking at various voting patterns and population changes. And so we certainly can't speak to the exact diminishment of any district, except for to say that, we'd like to take the legislature at its word that it was a reliably performing district when they passed that map for the governor's approval. And again, any district would need to go through a functional analysis in order to be.
Would it also have to go through an equal protection analysis and a racial predominance analysis? I mean, that's baked into anytime the legislature picks up the pen, all of those factors are in play, and it cannot ignore any of those things. Is that correct?
Yeah, absolutely. But certainly redistricting is something that takes a lot of time and trade-offs from the part of the legislature. But racial predominance is a very fact-specific, motive-based inquiry, and so it would kind of be turning the presumption of validity on its head for us to assume.
Well, if it's the one with the pen, though, it knows what it's drawing, correct? I mean, you can go to the drawer and say, why did you make that line that looks really strange? Well, because we needed more voters of a particular race.
Sure, and here we have no evidence of that. Again, the only district that's before this, the only map that's before this court is the enacted map, and that map, it's undisputed, does not comply with the Florida Constitution, and a trial court has found.
That's not disputed. I mean, that's not undisputed by the Secretary.
Correct. Sorry, it's undisputed that it diminishes, but that there is a question still about whether the jingles factors apply.
The Secretary argues that you failed at a matter of proof because there's not a valid benchmark, correct?
Well, those arguments are waived because, as Judge Tannenbaum mentioned, the only issue that was preserved under the stipulation for the trial courts or this court's resolution was the issue of whether the jingles factors apply. But there was never a question about whether the benchmark was a proper benchmark or whether plaintiffs had any.
Let me ask you about the jingles preconditions. So when the Florida Supreme Court says that the jingle preconditions are not only relevant to vote dilution but also to a diminishment analysis, can you tell us what we're supposed to understand from that?
Yeah, absolutely. So the Florida Supreme Court was referring specifically to the cohesiveness factor and the racial polarization factor. If you look at that footnote, then the Florida Supreme Court quotes Texas versus United States, which is a Section 5 case that explains that the cohesiveness and the racially polarized voting factors are relevant to a Section 5 analysis, but it makes no mention of jingles precondition 1, which is the numerosity and compactness problem.
Thank you, counsel.
Thank you.
Thank you, Your Honor. The 14 snakes hypothetical is actually just this case. The benchmark that the Florida Supreme Court drew in apportionment 7 is exactly that snake, and it is not a valid benchmark for all the reasons we were talking about. The Florida Supreme Court has not decided this issue, and the governor certainly has not defied the Florida Supreme Court. Instead, the governor sought an advisory opinion from the Florida Supreme Court in the redistricting process to try to resolve some of these open issues. And in the advisory opinion last year, the Florida Supreme Court expressly reserved the question whether the governor's arguments in that regard were correct, which I think shows conclusively that the Florida Supreme Court certainly has not resolved these issues, and we have not, the governor certainly has not defined.
Let me ask you
anybody.
a question about that on the equal protection front. So let's assume that you've made a very compelling argument that let's call it the prevailing interpretation of the Fair Districts Amendment is inconsistent with equal protection requirements. Why would we not first start by analyzing that under the Florida Constitution, which has its own robust equal protection provision that at least arguably is stronger than the federal provision? So if the court has never been asked to do that, why wouldn't we first take a crack at trying to read the Fair Districts provision in a way that is harmonious with Florida's equal protection requirement?
So, certainly, Your Honor, I think that's completely a reasonable proposal, and actually we mentioned that possibility in the Florida Equal Protection Clause in Article, or what's phrased slightly differently in Florida, under Article 1, Section 2. Obviously, it's been, as I understand the Florida Supreme Court's precedents, it has been treated as relatively coextensive. But one point we make in that regard is that I think one way the court could resolve the constitutional questions, which hasn't been, I don't think, came up in the discussion with counsel, is that you could construe the Fair Districts Amendment to contain an outer compactness limit that flows from non-diminishment itself to avoid these constitutional concerns. And I think counsel said in her presentation that there is no compactness requirement in the non-diminishment principle. And I think at page, I thought they took a different position at page 58 of their brief. But regardless, I mean, that certainly would be supported by the federal Section 5 of the Voting Rights Act guidance, which we cite in our reply brief at the end there in connection with citing the Equal Protection Clause of the Florida Constitution. And that, I think, would be another way to get there. There was discussion. So counsel mentioned that we've been criticized for not mentioning a specific district. You know, for the equal protection argument, there isn't a specific district. That argument doesn't apply to the benchmark argument, because obviously the benchmark argument is all about CD5 as it was enacted in the prior map. Counsel said it was undisputed that the prior map was legally enforceable. Not so. We vigorously dispute that. And certainly this was not resolved by the U.S. Supreme Court's decision in Abrams, which itself declined to give effect to a benchmark that was in effect for a time before it was indeed invalidated. Nothing in Abrams, however, suggests that this court cannot make that determination in the first instance. On the contrary, Abrams, I think, points in the other direction, because it says it's a constitutional problem to perpetuate a district in a map that is itself discriminatory.
Counsel, under Section 5 of the VRA, do you agree that race is permissible as consideration to protect a remedial district that has already been established? In other words, there is a compelling state interest in preserving a previously drafted remedial district under the VRA.
We think, Judge Tannenbaum, that in applying the non-diminishment standard to protect a district, whatever the benchmark is, necessarily requires race to predominate and would require the application of strict scrutiny in any such district drawn pursuant to that provision.
And if the benchmark, if CD5 had been a remedial district, this would be a different analysis. Like, then the consideration of race, or to what extent, it's a different feel than the one we have here where CD5 was not drafted.
I think it would be a different analysis in the following sense, Your Honor, because in the application of strict scrutiny, one of the ways the state can try to meet strict scrutiny is by identifying specific instances of past discrimination that is connected to the race-based remedy. In this case, there is absolutely no evidence, however, that the East-West district drawn in 2015 was necessary to remedy any kind of specific discrimination. So I think under that conception,
Counsel, are you still splitting time?
oh, I'm sorry, yes, and Your Honor,
probably
I
a
want
good
to
time
make
to-
sure Mr. Norby has time, so I'll sit down.
Very
Thank you.
good. Thank you.
Thank you. A few just brief points in rebuttal. The plaintiffs never, in all the discussion here and in their briefs, attempt to justify District 5 in Plan 8015 on its own terms. They say it maybe follows boundaries a little better than its predecessor, or they say it's not quite so bad compared to districts that came before it. But you've never seen in any of the briefing, even with an expanded word limit, any justification for the East-West District other than race. The plaintiff, and for good reason. The Florida Constitution does not allow non-compact districts other than when permitted on racial grounds under Tier 1. The comparisons with some of the other states are completely inapt. Some states justify egregiously non-compact districts on the grounds that those districts weren't racial gerrymanders, they were political gerrymanders. They were districts drawn to protect an incumbent. They were districts drawn to unite communities of interest. None of those are permissible factors to draw non-compact districts under the Florida Constitution. Similarly, it was somewhat bizarre to hear Congressional District 4 from the 2002 map described as an example of how districts naturally occur or are historically drawn in North Florida. Congressional District 4 in the 2002 map, let's remember, was a district that wrapped around Nassau County, north of Duval, and went down to Buck Lake Road. And it was a district that was an admitted partisan gerrymander in Martinez versus Bush, which we cited in our papers. The defendants admitted at a time when partisan gerrymanders were permitted in Florida that that district was drawn to benefit a Republican incumbent. At the time of the 2002 redistricting cycle, Florida didn't require compact districts. Florida didn't forbid partisan gerrymanders. That's why that district occurred. That certainly cannot be a justification for the non-compact district in Plan 8015. The closest we've heard to any justification of Plan 8015 on its own terms is that the plan follows borders better than a lot of other districts in the map. Well, certainly the plaintiffs are not suggesting that the predominant purpose behind the Jacksonville to Tallahassee district was the overriding predominant interest in ensuring that I-10 and the Florida-Georgia border were followed. That's not a reason to draw a district like that. The only basis on this record that could possibly justify the drawing was a race-based district, the attempt to comply with non-diminishment on racial grounds. My friends on the other side mentioned the Allen versus Milligan case in which they participated. That case provides a sharp contrast to what we have here. In Allen versus Milligan, the plaintiffs proposed 11 different alternative configurations that they submitted would be a compliant way of adopting it. They put on testimony by their map drawer as to all the considerations, communities of interest, and following things that could justify it other than on racial grounds. They haven't done that here. The only two maps they've submitted here either don't comply with the Equal Protection Clause or don't comply with the non-diminishment provision. And counsel never answered Judge Bilbrey's question about diminishment because District 5 in Plan 8019 plainly would diminish under a functional analysis of the sort that the court performed in Apportionment 1 through 7.
Thank you, counsel.
Thank you
Thank
very
all
much.
of you for your fine arguments. We're adjourned.
All right.